Let's begin with a true story. Supervisor of a local railroad station realizes there's a business opportunity here. There are a lot of employees working in this railroad yard. There are a lot of customers coming through here. I'm going to open a convenience store. And so he does. And the convenience store does very well. Until, that is, a man named Mr. Payne, P-A-Y-N-E, opens his own convenience store right next door to the railroad station and steals some of the supervisor's market share. In fact, he steals a lot of the market share. Higher quality product, lower price. The employees are going over there to shop, to eat their lunch, and so on. The customers are realizing that it's cheaper to shop next door at Mr. Payne's convenience store than it is inside the railroad station, and the supervisor sees his market share eroding quickly. So as a good businessman, he strategically decides to reclaim this market share. Can't do much about the railroad station customers going next door to Mr. Payne's convenience store, but what can he do? He can make a policy specifically with regard to his employees. And so he tells them, new policy, if I catch you shopping at Mr. Payne's convenience store, you're fired. No questions asked. This is a true story, folks. You're laughing. It's amazing what employers will do. Some of you know that firsthand. It's their new policy. If you shop over there, if I catch you over there, you're fired. No chances. Whether you're on duty or off duty, I don't want you in that store. I don't want you patronizing this guy. Now I ask you, is that legal or illegal in the United States? Todd?
Well, according to the kind of employment contract, employers can fire you for any reason. But I would also think that that applies to any workplace reason, and not when you're out of your regular working hours.
So you'd speculate that he could apply that policy when they're working for him, when they're being paid by the railroad company, but not when they're off duty.
I would say so.
Okay.
What do you mean off duty, sir?
Off duty. They're not on the clock. They're not working for the railroad. They're.
The reason why I say that in the military, we have a blackball list. Whether you off or on, they tell you you can't go. So it's legal in the military. I'm not sure about the private sector.
Yeah, we're talking specifically private sector right now. Legal or illegal? What do you think? Can he fire them for what they do off duty? Can your employer actually tell you what you can and can't do when you're not working there? So if he caught you in Payne's convenience store and he fired you, you would have some sort of legal recourse. You could get your job back, you could sue him, you could hit the lottery, win lots of money, cash and prizes all come your way, because he took action against you for something you did on your own time. Is that sort of the feeling in here? I'm not asking you to be legal experts. I'm just trying to get your sense of this. Let me make this perhaps a little bit easier. This is the state of Tennessee that we're talking about here. Now, can he fire them for their off-duty conduct? Jen?
Well, I don't know about the state of Tennessee in particular, but I do remember something in the reading that said that employers cannot fire employees for doing things off-duty that are legal. And shopping at a store, there's nothing illegal about shopping at a store. And I think that law or rule may be at the state level and not at the federal level, so maybe that's where your comment about the state of Tennessee comes in, and I don't know about the state of Tennessee.
Okay, let me make this even easier. This is the year 1884. Now what's the answer? Yes, what? Yes, he can fire them for what they do off duty? Why is it different? Okay, good. What is the prevailing doctrine in 1884? Employment at will, right? If you don't understand employment at will, you will not understand U.S. employment law. What does the employment at will doctrine say? Okay, yeah, that's pretty good. Let me make it a little more formal. An employer can do whatever it wants with respect to the employees. That's not too formal. Let me make it even more formal. You could be fired for a good reason, or for a bad reason, or for no reason at all. Even for a reason that's morally wrong. You can be fired for a good reason, or for a bad reason, or for no reason at all. And in the in the case of Payne versus Western and Atlantic Railroad, 1884, the Supreme Court of Tennessee, the court said, employment at will prevails. All right, that is what's going to prevail in any kind of employment relationship. The employer can do whatever the employer wants to do. The first judicial articulation of this doctrine. And, similarly, the employee can leave at any time for any reason. Fair is fair. This is a moment-to-moment employment contract. All right? I agree to hire you for this moment. You keep working. You agree to stay for that moment. It's a moment-to-moment doctrine. Moment-to-moment employment contract. What do you think of that? Employment at will doctrine. Fair is fair, right? You can leave at any time as the employee. You can take all the training that I give you and then just go work someplace else. I can train you at my convenience store in the railroad station, and then you can go work for Mr. Payne. I have no recourse as the employer. But, level playing field, I can fire you for a good reason, for a bad reason, for no reason at all. Okay? Does that make sense to you? Does that seem fair to you? Well, you know, why isn't it a level playing field? I see a lot of head shaking here. Why isn't employment at will all that fair from your perspective? Marcia?
The employer's got the power in this relationship.
In most cases, the employer has a lot more power than the employee. You need that job a lot more than that employer needs you. Regent University could fire me and just replace me with somebody else. I got to relocate my whole family of 6 now, including a big 15-pound cat, to someplace else. That's the biggest problem of all these days, in fact. All right. Cat's my best friend, displaced from her room. Anyway, we'll cut that out for the distant students. All right, but it's really not fair because the employer has the power here. So under the employment at will doctrine, I could fire you because of the color of your skin. I could fire you because you get pregnant. I could fire you because you don't acquiesce to my sexual advances. I could fire you because I don't like the color of your socks. I could fire you for one unexcused absence. I could fire you because of a personality clash. I could fire you for any reason I want. A good reason, a bad reason, no reason at all, even a reason that is morally wrong. All right, that's the employment at will doctrine in its rawest form. Now I ask you, does the employment at will doctrine exist today, in the year 2000, in the United States? Yes, it does. The employer can still fire you for a good reason, for a bad reason, or for no reason at all? Well, yes and no. Todd?
Yes and no. It's modified. Can't fire you because of your race or origin and certain things, but basically the employer can still fire you at will.
Okay. Employment at will remains the default condition, if you will. All right? If nothing else applies, if there's no law or court case that protects you as the employee, the employment at will doctrine prevails. And in the module, we had a little pie chart. Try to recreate it here on the board. Over the last 70 years or so, what we have done in this country is to create exceptions to that employment at will doctrine. All right, boy, that is one bad pie chart. You don't want to look at that all night. Let me fix it just a little bit. All right, we got a good radius there. Okay, good. Now, we have created exceptions to the employment at will doctrine. There are things that you probably were familiar with before you came in here, statutory exceptions. What are statutes? These are laws. Laws codified by the federal government or by the state government. We can also think of city ordinances here as being statutory exceptions to employment at will. Right, some legislative body has specifically crafted exceptions. You can't fire somebody because of race, sex, religion, national origin, because of Title VII of the Civil Rights Act, and we'll talk about that a little later. You can't fire somebody because of their age. We have the Age Discrimination in Employment Act. You can't fire somebody because of their disability. Right? We have the Americans with Disabilities Act. You can't fire somebody because of their union status or leanings. We have the National Labor Relations Act. Right? We have several laws here at the federal level that cover employers in every state, employers of generally 15 or more employees. And then we have further laws at the state level, some of which parallel the federal laws and cover smaller employers, and some which expand employment law. For example, in a handful of states, you can't fire someone because of sexual preference. Right? That's not a federal law. It doesn't cover all 50 states. It doesn't cover employers everywhere, but it does cover employers in that jurisdiction, in that particular state. Right? And then we have city or municipal laws that cover employers just in that jurisdiction. So Virginia Beach could further extend employment law, right, beyond what it is at the federal level or the state level. So you as the manager have a lot to be cognizant of. You have a lot to stay on top of here. Okay, so we have federal, state, and local statutes or ordinances that are exceptions to employment at will. You're an employee at will except if we've written some law that protects you as an employee. All right, and we typically refer to all this on the bottom of the pie chart here as anti-discrimination law. Now, on the top of the pie chart, we have a couple of pieces, one, which we call together common law exceptions to employment at will. These two pieces up top, we have a contract exception, which you read about, and we have something called a public policy exception to employment at will. What are common laws? What does common law mean? Some of you have some training in this area. Well, yeah, it's going to predate this country. It goes back to England. Marcia?
Law based on precedents.
Law based on precedent, and there doesn't have to be any statute that applies. Right? And we'll see how that works. This is essentially a judge handing down a decision, a precedent, and in that judge's jurisdiction, whether it is small or it is large, this exception to employment at will has been created. That decision is, in fact, binding on employers, independent of what the legislative body has done. So we're going to have this judge-made law, this common law, coming into play here as well. But if you're not protected here under this contract exception, and you're not protected here under this public policy exception, and you're not protected here under the statutory exception to employment at will, what happens? Employment at will is the default condition. The employer can do whatever the employer wants to do unless some law or court case says otherwise. Okay? So yeah, employment at will still does exist in the year 2000. And it may always exist in this country. It is part of our heritage here. In fact, at a meeting of, if you just want to see how we stand against the rest of the world on this particular subject, there's a meeting a few years ago of the International Labor Organization, which is about 140 countries get together and discuss labor policy. There was a non-binding resolution on the table that basically said employees should only be fired for just cause. Employees should only be fired for just cause. That's a different paradigm from employment at will, is it not? Here, employers can be fired for employees can be fired for any reason, right? But there was this resolution on the table: employees can only be fired for just cause. Non-binding. Do you agree with it? 134 countries agreed with it. The countries that did not agree with that non-binding resolution were, if I recall, Chile, Brazil, Saudi Arabia, Iran, Iraq, and the United States. Now, that is not a shot at our country, folks. That is just evidence of how firmly rooted this doctrine is. A non-binding resolution internationally, we still will not sign on. This is part of the employment relationship. Right? It goes back to private property rights and so on in the Constitution. We're not going to get into that kind of detail, but that's how firmly rooted it is in our heritage. All right, any questions about this employment at will doctrine, at least the basic framework of employment law? Make sure, if you understand nothing else tonight, you understand this framework. Because a lot of employers, a lot of managers I've talked to get this completely backwards. They think they have to have a performance-related reason to fire somebody. Well, it's a good idea to have a performance-related reason, but do you need one? Is there any law that says you have to have a valid performance appraisal system? Is there any law that says you can only fire somebody if they're a bad performer? Well, if there's not, then you can do whatever you want. You can fire the best performer you have, right? As long as there's no law or court case that says otherwise, then you're on firm legal ground. Okay? So, employment at will doctrine. You can do whatever you want unless some law or court case says otherwise. Now, let's go into some of the specifics. Contract exception. We have explicit and implied contracts. What might be an example of this contract exception to employment at will? Any of you contract employees, do you have an employment contract? You do. And what does your employment contract say? You're there for a particular period of time guaranteed in most cases, right? You're not, Melissa. Are you, Robin?
I am ex-contractor.
Okay. At one point, you had a term for that agreement. You're going to be employed here for this period of time. We agree not to fire you, not to get rid of you for this period of time, right? Except for maybe some egregious things. I'm a contract employee. I have a 12-month contract with Regent University, right? Am I an employee at will? No, I'm not anymore because it says right in that contract that they're only going to fire me for a good reason over this 12 months. Otherwise, I get to stay here and bother you folks for this whole semester. Right? So there are specific employment contracts. Very few employees in the United States have these. But specific employment contracts, I sign, my employer signs, you're going to be here for a year or 5 years or whatever we agree to. It is an exception to the employment at will doctrine. Right? I'm not an employee at will anymore. Any of you work in a unionized organization? Andy, you've worked in a union shop or something like it, where you had to be a union member or...
required, but it's basically an accepted norm.
But you were covered by some collective bargaining agreement. And what did that collective bargaining agreement say with regard to terminating someone? Robin?
It had to be for a specific reason and could not be for these specific reasons. It had stated in there that... like if you could take it to file a grievance and take it to arbitration.
Right, there's steps in there. There's a grievance procedure most of the time leading up to arbitration. There's almost always a clause in a collective bargaining agreement that says you can't be fired except for just cause, except for a good reason. And there is this procedure, etc. Now, if you can't be fired except for a good reason, what do you make of employment at will? Does it apply in that unionized organization? No, it doesn't, because we have subverted it. We have a new agreement, this collective bargaining agreement. Okay, so that would be an exception to employment at will. What else falls under this contract exception? What did you read about, Jen?
The implied contracts that are...
Sure.
Oh,
Whatever
that you
want.
find in like an employee manual if there's something stated in there that's specific.
Okay. How many of you have an employment manual, a policy handbook of some sort? Okay, probably about 30, 40% of you. How many of you took it out this week after reading your... How many of you have it buried at the very bottom of your desk drawer? Yeah, that's where mine is, too. Well, some courts in some states have found, as you read, that this personnel policy manual may in fact create an exception to employment at will. How does that happen? Well, the same way it happens with collective bargaining agreements. If there is a clause in there from your employer that says you'll only be fired for a good reason, you'll only be fired for just cause, well, has the employer created a contract? We're not going to get into all the legal nuances, but in about 40 states, courts have said, yeah, these personnel policy handbooks are in fact contracts. Why? Do you have any idea? They're not signed by the employee. They're not signed by the employer. The employer can change it unilaterally. How many of you can change your contracts unilaterally? How many of you would like to go and change the numbers on your mortgage agreement? I would. Contracts just don't work that way. But this personnel policy handbook contract does. Why is it a contract? Well, this is where we get into how common law works. There's no statute that says handbooks are contracts, that an employer is bound by them. Right? So if the employer's made a promise to you in a handbook and then the employer unilaterally violates that promise, can you turn here to the statutory exceptions, to statutes, to the EEOC and so on for recourse? No, you can't, right? Because there's no law that covers you. However, judges in various states have said this simply isn't fair. You, the employer, created an expectation that you would only fire people for a good reason, and then you broke that promise. You created an expectation. It's not fair for you to then fire somebody for no reason at all. All right? Well, what is that based on? Who says that's fair or unfair? Whose decision is that? Strictly the judges. Right? Common law is based on the judge's values and a little more. All right? So what we have here is judges saying this isn't fair, therefore these policy manuals are going to be contracts. You're bound by what you put in there. Okay? Except if what? Marcia? Yeah, what's a disclaimer? Look for this, folks, and look for it on either page 1 or the last page of your handbook. Go ahead.
Anything within the book is not intended to be policy for the company. It can be changed.
Right.
Those of you who looked at your handbook, was there a disclaimer in there? There is in mine. Right? It says right up front, in plain English, usually in big type, this is not a contract. You remain an employee at will. And courts have found if, in fact, you put a disclaimer in there, what have you done? There's no more expectation that you're going to be bound by this. You've taken the expectation away on the employee's part, and therefore it is fair for you to go and unilaterally violate what you put in your personnel policy handbook. That may not be good management, but strictly from a legal perspective, you can do that. All right? Some of you may notice, I don't know if it's in the Regent University catalog or not, but some university catalogs have a disclaimer right up front that says this is not a contract. In a catalog. Why is that? Some of you have come in under one curriculum, and lo and behold, we've changed it not one time, not 2 times, but 3 times, and that's not fair, and really, we've had the customer in mind every time. In our own defense, it's just getting better and better and better, and we're doing whatever it takes to give you a good education here. Hey, it's part of business. You understand organizational change. But, yeah. We'll get into that some other time. But the point is that some college students have sued their university, saying you created an expectation on my part that if I had these 120 credits and I did all this stuff, you owed me a degree. Now it's 140 credits. I don't have the money, nor do I have the time. That's not fair. Courts have agreed with them. All right, so there are disclaimers even in university catalogs for the same reason as you find them in personnel policy handbooks. Okay, that's one type of implied contract. There's another that you read about. What about, say we're sitting in an interview, and I promise to you, I tell you, I'm really trying to attract you. You got this Regent MBA, and we need folks like that here at Webster. I tell you, if you're loyal and you do a good job, you'll have a job for life here. If you're loyal, you do a good job, you don't undermine us in any way, you keep doing a high performance, decent job, you'll have a job for life. Well, have I undermined the employment at will doctrine? Are you an employee at will? I haven't stated any disclaimer there. I've just made you a promise. It's ambiguous, but was it ambiguous to you? You're sitting there in the interview chair. That sounds pretty good to you, doesn't it? If I'm loyal, I can do that. You know, if I'm a good performer, well, I always have been. I have a job for life. Well, this sounds like a better job offer than the next one. Todd?
But doesn't that only apply to the person making that promise?
Well, the person making that promise is an agent of that employer. And as we're going to see, especially in sexual harassment law, and also in discrimination law, these agency principles will apply. That what you do as an agent of the employer is therefore liable and bound. All the more reason that you as managers need to know this stuff. All right? So, good question, but usually the employer will be bound by what its agents do and say. Well, the short of it is, in some states, handful of states, maybe 13 states or so, the more pro-employee states, like California and Massachusetts and New Jersey and Vermont, and the more liberal states generally in our country, have found that almost any employer promise, verbal or written, can in fact undermine the employment at will doctrine. All right? Now, you really have to watch what you say. You have to treat employees consistently, these courts say, and you have to keep your promises. And if you don't, then you may be liable. Then you may have just eviscerated this employment at will doctrine. Yes, John?
If that statement is said to an employee, how can that be proven? If
Yeah,
it's
well,
just
that's
an
the
oral
tough
statement?
part. It's just you and this person in the room, right? I don't think they have the tape recorder going that you're going to find in disclosure, and you're going to be able to use that in court. So, yeah, tough to prove. Question, Sylvia.
Nothing is binding until it is in writing, pretty much.
But not necessarily in this case.
But I mean, in the situation you were talking about, he can make all the promises he wants. But if the employee doesn't have that in writing, he comes back and he's expecting something when he comes on the force, and it's gone.
Yeah, that may be true, but there's a case in California where 32 years later, in a general reduction in force, an employee sued saying, in the interview you told me if I were loyal and I did a good job, I'd have a job for life. And that employee won. Okay? Strange things happen in California, yeah, we recognize that, but still, that's what can happen. You don't know where you're going to be working after this, right? So you're going to want to be aware that sometimes verbal promises will, in fact, undermine this employment at will doctrine. Okay. Questions about that? Yes?
These sort of oral promises were made in front of an entire room full of people, but you sign a contract that doesn't have that particular stipulation in it.
Mm-hmm. Yeah.
I mean, it comes down to people.
Comes down to who the jury likes more, who's more credible. Juries aren't made up of CEOs, folks. I got news for you. They're made up of common folks who will sympathize with the plaintiff more than they'll sympathize with you, the manager. Okay? All the more reason that you're going to want to be careful about what you say to employees. You're going to want to be very careful about what you put in writing, because then they have something tangible in front of them.